it was certainly not in the cards for me to become an attorney years ago, and certainly not an environmental attorney. And I was the grandson of a coal miner and a steel worker, the son of a chemical worker. I grew up in the most polluted city in the country, I think, Charleston, West Virginia. 8 huge chemical plants in one little valley. And so the best thing you could do if you were in Charleston, West Virginia was to become a chemical engineer. And so I went to school to become a chemical engineer. And when I first started practicing environmental law, much later, we could have had this conference in a bar on the Strip on Cumberland Avenue. I mean, around one table. That's how many public interest environmental lawyers there were back then. Now, look at the group we have here. I don't know if any of you have been to the Public Interest Environmental Law Conference in Eugene. I mean, there's hundreds of lawyers and activists who come to that every year. It's a little different going to that one than it is coming to this one. The last one I attended out there, Julia Butterfly Hill was the keynote speaker. I don't know if you know her. She's the woman who sat in a redwood tree for over a year to keep the tree from being cut. And she obviously had a lot of time to think and compose her speeches because she was a fantastic speaker. And until she was interrupted by some women who were protesting the fact that she ended up buying her tree after she got royalties for her book. And I didn't quite understand that, but these women stood up in the middle of her speech, took off their shirts, and had written on their breasts, "Julia sold out." So things are a little different in Knoxville. I don't expect that during my talk today. But like I said, oops, I didn't mean to do that. I was, here's John Bonein's statistics now on how many public interest environmental lawyers there are. About 750 in 2009. That's still not very many. I mean, obviously you're a rare breed of attorney if you practice public interest environmental law. And Jamie and I call ourselves, and this is what the term that John Bonein uses, private public interest lawyers. I mean, we're in private practice doing public interest environmental law. And there's only about 250 of us, supposedly, so we're an even rarer breed. I've been very, very fortunate, blessed is what I would say, I thank the universe, I thank all kinds of goddesses and gods, because I've been able to do this for 30 years, and I've never had to compromise my principles in order to represent clients and to advocate with the law. I was a 19-year-old chemical engineering student in 1971 when Barry Commoner's book, The Closing Circle, came out. And his 4 laws of ecology, which just resonated with me. It made me an environmentalist at that time, and it still resonates. He died last year, September 30th, and that's one of the reasons that I thought about him when I was working on this talk this morning. Everything is connected to everything else. I mean, that's the obvious principle of ecology. Everything must go somewhere. This one really resonated with me at the time because there's no a way that you can dump waste, for instance. That's what that stands for. Nature knows best. That also resonated with me as a chemical engineer, because what Barry Commoner talked about was that there are certain forms of chemicals that were not made by nature that inevitably are going to cause harm if we introduce them into the ecosystem. And he particularly focused in his book on chlorinated organic chemicals, which we all know are persistent and cause various forms of toxicity to organisms. And I mean, they're the ones that I decided to focus on later when I became an attorney. And there's no such thing as a free lunch. Anything we do in the environment that takes energy, that takes materials, we end up expending those materials. We ended up reducing them to a lower form of energy to the point where you got to pay somewhere. And so this really resonated with me when I read this. I decided to become an environmentalist, and ultimately ended up 10 years later, when this Time cover came out, becoming an environmental lawyer. This was what kind of ushered me out of the University of Tennessee College of Law, was this cover of Time magazine, as I was going to work in California to become a policy analyst with Jerry Brown in his second term. I think he's in his third now, with the Toxic Waste Assessment Group. And so I was wondering at the time what a chemical engineer could do with environmental law, and this happened. Love Canal became a national watchword, and Time ended up putting this on the cover. Now, after 30 years, or more than 30 years of practice, with apologies to Barry Commoner, I have decided to formulate my 4 laws of public interest environmental law practice, and that's what I want to talk to you about today. The first one, I'm going to go through these. I'm going to give some case examples as we go through them. It's all about making an impact. I mean, everyone knows that. 2, you get by with a little help from your friends. 3, you must be the change you wish to see in the world. That sounds very New Age-ish, but I'm from Asheville now. So, and 4, desperate times call for desperate measures. So I'm going to illustrate these as we go through them. Well, the first one, it's all about making an impact, and here's another phrase or another saying you hear a lot: never doubt that a small group of thoughtful, committed people can change the world. Indeed, it's the only thing that ever has. That was Margaret Mead who said that. And my version of that is, why else would you do such crazy shit? I mean, the things that we have done, I have done, and a lot of you have done in order to try to make an impact in the world, most sane people wouldn't choose that path. And I certainly wouldn't invite anyone to follow the path that I have followed, but I really have enjoyed doing what I've done, and I feel like I have made an impact. The first case I worked on, and I'm going to tell you a little bit about how this started. I was just I just came back from California, came back to Appalachia, to Knoxville. We started an office of the Legal Environmental Assistance Foundation, LEAF, here in Knoxville in 1983. Dean was on the board, and we had an opening reception, and maybe a lot of you know Carol Nickel too. She's been a long-time lawyer in Knoxville, and Carol was my law partner at the time. And so we had this little LEAF office here in Knoxville, had an opening reception, and these 2 guys with long hair and blue jeans, of course that applied to just about everybody at the time, came up to me during the reception and said, "We'd like to speak to you in private, please." And I ushered them into my office, closed the door, and they proceeded to tell me about the Y-12 plant in Oak Ridge and the environmental disaster that it had been making over 40 years of enriching uranium and working on nuclear weapons. And one of those 2 long-haired hippie types was Barry Salkin, and a lot of you know Barry. And the other was a deep throat, whose name I won't reveal even this long from that time. And they proceeded to tell me about the Y-12 plant, and here's another view of it. At one time, this started in 1943. This was one of the plants in the United States that was built during World War II to make the first nuclear warhead. They had a uranium enrichment process. They were working on plutonium as well. And at one time, during the 1940s, during the war, there were about 2,200 people working at this location. Later on, during the Cold War, there were 8,000 people working there. So a big, big deal in East Tennessee. And among other things, it used a lot of mercury. And in the early 80s, around 1982, late or early 83, it came out that East Fork Poplar Creek, which is downstream from the Y-12 plant, was contaminated with mercury. And it was posted by the Tennessee Department of Health and Environment at the time for mercury contamination. Someone started asking, well, where's that coming from? And a reporter from a newspaper in Clinton, what was that paper called at the time, Dean? Do you remember?
Ed Slavin.
Ed Slavin, yeah. Did a Freedom of Information Act request, and amazingly enough, the Department of Energy gave him some documents that showed that 2.4 million pounds of mercury had been released from the Y-12 plant during the 50s and 60s. And they just lost it. They lost it in the creek, they lost it in the ground, it was unaccounted for. At one time, 1/3 of the world's mercury supply was in use to generate lithium-6, which was an isotope that was used in nuclear warheads at the Y-12 plant. And they lost a bunch of it. Well, and that led to inspections by, forced inspections almost, by the Tennessee Department of Health and Environment. Barry Salkin was the inspector who went out there and insisted on inspecting the plant. Somehow or another he got in, and that led to his visit to my office that day in February of 1983, which he was frustrated because his supervisors wouldn't take the next step, which was to take enforcement action against the Department of Energy for the pollution at the Y-12 plant. I showed the East Fork Poplar Creek here. It wasn't just mercury that was being released into the creek. It was all manner of chemicals used in the machining of uranium parts for nuclear warheads. And this creek flowed down several miles to where it left the Oak Ridge Reservation, and the state and the Environmental Protection Agency had made the Clean Water Act permit so weak that it only applied at the boundary of the reservation on the creek. It didn't apply upstream where the discharges occurred. There were over 200 pipes discharging into the creek at its headwaters on the reservation. None of those had permits. The permit was at a point in the creek where it left the Oak Ridge Reservation. So that was one of the things that we noted that was probably illegal. And another, and these were described to me in vivid detail for a couple of hours in that first meeting. Later we got documents that showed more details. There were these pits or ponds called the S3 ponds on the site too. And these were a witch's brew of uranium, nitric acid, heavy metals, solvents, you name it. They dumped them into these ponds because the stuff went out the bottom. That was the reason they used these ponds, because it just disappeared. Going back to Barry Commoner, there is no way. It was going into the groundwater. It was going into the East Fork Poplar Creek. It was going into the Tennessee River eventually. And so this was obviously a violation of the Resource Conservation and Recovery Act, hazardous waste rules, and it was a violation of the Clean Water Act as well. They used these things for 32 years, so you can imagine the quantity of materials that were dumped during that time. They also were burying all manner of chemical and radioactive waste in unlined pits. And when they would fill a pit up like this, they would take a pipe and stick the pipe in the ground and dump more liquid waste into the pipe. Again, it was going into the groundwater, obviously, going into the streams, going into the river. And then they had another scheme at the time of spreading PCB waste on the ground with the hopes that soil bacteria would degrade the PCBs. And of course it didn't work. It was running off into the streams again. There were PCBs in the streams. So all this was related to me by an engineer who had firsthand knowledge about it, Barry Salkin, who had inspected the plant and written a report about it, but no one was doing anything about it. And I had never filed a lawsuit in my life. But I knew that this was big. I knew that this could be a huge impact, and it was the first lawsuit I ever had. I was a little concerned about that, and so I talked to Dean, and he was on the board of LEAF, and we decided we needed to bring in some help, so we brought in the Natural Resources Defense Council, and they worked with us on this. They were very dubious about this. You can't beat the Department of Energy. You can't challenge the federal government. I mean, they make nuclear weapons there. I mean, they're probably exempt. As a matter of fact, that was the position taken by the Department of Energy. This is a memo written in November of 1980, before the RCRA regulations came into effect, that said, sent to EPA Region 4 from Oak Ridge, saying all the wastes are generated by activities authorized by and subject to the Atomic Energy Act. An exemption from RCRA regulations is applicable and no permit application accompanies this letter. So they said they were exempt. We cajoled NRDC into helping us with it, and we ended up filing and we had no other choice but to file here because of the venue requirements of the Clean Water Act and RCRA. We filed in the Eastern District of Tennessee in September of 1983, a citizen suit under RCRA and the Clean Water Act. We had a judge who was 84 years old at the time, not known to be an environmentalist. His name was Robert Taylor, and we were concerned. I mean, everyone was concerned that we were going to get royally screwed with this. And DOE came out and said, we're going to comply with the spirit of the law, and we have a memorandum of understanding with the Department of Energy, and so you don't have to worry about this lawsuit. I mean, you just go away. And we refused to go away. Amazingly enough, Department of Energy, they admitted all of these violations. They admitted that they were dumping the waste in the S3 ponds. They admitted they were putting chlorinated solvents in the pits, etc. But they relied upon this exemption. This Judge Taylor had what people would call a rocket docket today, because you don't get motion practice moving very quickly in federal court these days. We filed a summary judgment motion in, I believe it was January of 1984, and we had a summary judgment hearing in April and had his decision that day. I mean, that is just, it never happens. As a matter of fact, we had a room full of attorneys arguing this case, and at our council table we had Dean and myself and Barbara Finnemore from NRDC, and on the other side there were at least 17 attorneys. We had the deputy litigator, our chief litigator from the Department of Justice, and he had probably 6 or 7 attorneys. EPA had attorneys, TDEC had attorneys. There were at least 20 attorneys over there. Martin Marietta, Union Carbide, they all had attorneys. And when I got up to argue on this, the only question that Judge Taylor asked me the whole time was, and he just sort of looked up, he was 84 years old, Truman appointee, said, "Where are you from?" And I was the only one in the room, other than Dean, that had the right answer, which is right here in Knoxville. and he did not like government attorneys one bit. I think that overcame his reluctance to do something good for the environment. And so he started reading from, after we all sat down, that was the only question he asked to anybody. After we all sat down, he started reading from his opinion. It had already been written. And he was so senile, he read 1 page of it twice. And we had to sit there and listen to him read 1 page of it twice. And Dean reached over to me and elbowed me and said, "Don't smirk." So that was, as I said, the most impact I'll probably ever have in my legal career. I just happened to be in the right place at the right time, because what DOE did after that is it decided to, well, here's the decision, what the judge ordered that day. first of all, he found that the Atomic Energy Act does not exempt their chemical and hazardous waste, other than purely radioactive waste, from Resource Conservation Recovery Act rules. Secondly, he found that you can't put a permit limit on a stream miles below the sources of the pollution, and that you can sue over that and make the permit apply to the pipe. And so we were able to apply the permits to the pipe, and the judge wouldn't enjoin them because it was nuclear weapons after all, and it was still the Cold War after all. But he did order them with all deliberate speed to file for permits and get permits under RCRA and get Clean Water Act permits for all the pipes at the Y-12 plant. To DOE's credit, they decided not to appeal this. I guess they had a change of heart about this, and they ended up applying this decision to all of the nuclear weapons facilities throughout the United States. There were some hiccups along the way. NRDC had to sue over the Savannah River plant, but it was far surpassing any impact I ever thought we would have from filing that little lawsuit here in Knoxville. And as a result, all of these nuclear weapons complex facilities are being cleaned up. There's probably more money being spent on cleaning up the mess now than there is on making any new nuclear weapons. And that happened sometime actually in the 80s when that happened. Because they really stopped making nuclear weapons back then. But here's the nuclear weapons complex. I'm just show you a map of that. I'm not going to go into any detail, but it's a huge complex throughout the United States. Let me see this. I had but it's not over in terms of Oak Ridge, and I just want you to be aware of this, that there is a planned uranium processing facility for Oak Ridge that will be built at the Y-12 plant, and it's already a boondoggle of the highest degree. I mean, number one, there's a lot of questions about whether we need to be processing any more uranium, and number two, or making any more nuclear warheads for that matter. But number three, the cost overruns have been billions. I mean, it was estimated in 2005 to cost about $600 million. Now it could be $6.5 billion, or it might be $11.6 billion. And at a time when we are having trouble paying for Head Start programs, I mean, it's kind of ridiculous to be spending that kind of money trying to rev up the nuclear arms race again. But anyway, I just wanted to close out that particular law of public interest environmental law practice by saying you can have one hell of an impact if you just forget about trying to make money, forget about all the concerns you would have in bringing a case against the Department of Energy for their nuclear weapons plant, and you just go forward and do it. I had the FBI following me during that whole lawsuit, and it wasn't pleasant, but again, it was all downhill from there. I don't think I'll ever have another case like that in my entire career, especially not one that only takes 8 months to bring to resolution, and such a good resolution. Another law of public interest environmental law practice is you get by with a little help from your friends. And you need all the friends you can get, and you need friends in strange places too. And I'll explain that a little bit. Obviously you need connections with environmental groups if you're going to be in public interest environmental law practice. I've had connections in the Legal Environmental Assistance Foundation. We represented groups that NRDC or other public interest environmental law firms wouldn't touch. We represented citizen groups, community groups, people who lived around landfills. It wasn't always the biggest impact litigation, but you get to know a lot of people. And you get to know a lot of people who are victims of environmental pollution who aren't environmentalists, And so these are your friends too. And you can't discriminate against who you work with by only associating with people of like mind. So you need friends in a lot of different places. I also found that it's good to have friends who are trial lawyers. You might not normally think of public interest environmental lawyers as hanging out with fat cat trial lawyers, but it's a good place to hang out. It's a good place to hang out to learn a lot about practicing law, to learn a lot about trying cases. You need to be a trial lawyer to be a public interest environmental lawyer, to be a good one. And I associated myself early in my career with Sid Gilreath, who's a well-known plaintiff's trial lawyer here in Knoxville, and I learned a tremendous amount. He had just tried and won the first big toxic tort case in the United States, which preceded the Wilburn, Massachusetts case that became the book and the movie A Civil Action. And you didn't hear much about the case in Toontig, Tennessee, because it wasn't near the Boston media market or the New York media market. But Sid tried this case in front of a judge over the course of a couple of months, put on experts, even though he's not an engineer, and got a judge to award these people some pretty serious money and punitive damages against Velsicol Chemical. It's the Sterling versus Velsicol case. It ultimately became a Sixth Circuit decision, which upheld most of the judgment that Sid got. So I started working with him after he had won that case, and we started doing toxic tort cases all over the country. In addition to my other environmental law practice, I learned a lot. So don't shy away from working with people who might not have the the values that you do on the environment. He might have been in it just to make money, but I go to American Association of Justice meetings now, and I think there's some true believers in a group of trial lawyers all over the country, and they're doing some great work. So, friends in strange places. I also have been working a lot with a firm that does corporate defense work too, but they do some plaintiffs work. And I'm going to talk about the next case here, TVA coal ash spill. This is what happened on the early morning hours of December 22nd, 2008 in Kingston, Tennessee, just down the road here. There was a 90-foot dam of coal ash holding back billions of gallons of coal ash sludge. It's like, toothpaste holding back toothpaste, basically. This dam failed catastrophically, and 1 billion gallons of coal ash sludge as a tsunami swept out into the Watts Bar Reservoir, covered about 300 acres right around it, and the ash kept on going all the way down to the Watts Bar Dam. The amount of coal ash released makes this at least in terms of volume, the biggest environmental disaster. It's even 5 times larger than the BP oil spill, about 100 times the size of the Exxon Valdez spill. You're looking south from where the dam collapsed. The dam had been around here, and all that coal ash sludge just swept out, created about a 40-foot wall of water and coal ash that swept up onto people's properties. You can see the aftermath of one home that was right across it was actually a little cove in the lake there that knocked it off its foundation. Amazingly, these people survived. The ash went all the way down the river, and as I said, all the way down to the Watts Bar Reservoir. For months, they were cleaning up ash from people's property, their boat docks. I mean, those of you who live around here, you know that Watts Bar is a beautiful lake, that people live on the lake and have a great lifestyle with boating, water skiing, fishing, and all that was ruined in the space of an hour that morning on December 22nd, 2008. Again, it was the river was closed for a period of time. There was an advisory against recreating in Watts Bar. EPA put up signs there. The river was closed for a period of time while they had to dredge out the ash that was clogging the channel of the Emory River. So I had a call as early as January 1st of 2009 from a member of the Southern Alliance for Clean Energy, which I'm on the board of. And she got me involved with the community there. We ended up with over 300 clients in the area around the ash spill. And I didn't know much about environmental disaster work at the time, and what I didn't fully understand is how whenever there's a disaster like that, a lot of lawyers come in to town from all over the place. And we had Erin Brockovich come to Knoxville, to Kingston to speak, and she was at that time working for a firm called Whites and Luxembourg out of New York City. And so she signed up a bunch of clients for them, and a firm out of Nashville came in, actually San Francisco and Nashville, Leaf to Brazier, a firm from Birmingham, Alabama, called the Friedman Leak firm. And so there were lawyers descending on Kingston like you wouldn't believe. And I had never done a class action before, so I decided that we needed a big firm to work with us, and so we got the Beasley Allen firm out of Montgomery, Alabama to help us because we figured there was going to be a class action here. I didn't think it was necessarily the right thing to do, but if there was going to be someone filing a class action, we wanted to be part of the mix for our clients' benefit. So I ended up getting to know the world of mass tort litigation as a result of this case, and the world of these big firms that go from disaster to disaster, or drug to drug, or car product liability case to another product liability case. And it is a different world than environmental law, that different world than we usually know as public interest environmental law practitioners, but these are good friends to have. When you've got a firm like the Beasley Allen firm that has 50 lawyers and 200 support staff, and when we ended up filing suit and going to trial here in the Eastern District of Knoxville, of Tennessee in Knoxville, we had a war room. We took over a floor of the Hilton Hotel, and we had essentially a whole law office there, courtesy of Beasley Allen. They brought a tractor trailer into Knoxville and set it up. So I mean these are good friends to have as a lawyer. We ended up trying the case over the course of almost a month in 2011, the fall of 2011, what the court did at the time was to bifurcate the case and try liability first, because TVA, amazingly enough, even though their dam failed, it was classic res ipsa loquitur, they contested liability. They should have admitted liability, and then they tried to claim that they were immune because it was a policy decision or two or three that led to the failure of the dam. We had to thread a needle throughout the whole case to avoid that immunity. And I won't go into the details about that, but and during this trial, we brought out a lot of things that, I don't know if you know Judge Varlin here. He was our judge, and we tried it without a jury because he didn't give us a jury. We asked for one. We tried to certify a class. He wouldn't certify a class. So that's why we ended up trying the liability first, because we had 7 law firms representing over 850 clients who were trying to get a trial in this case. So we tried liability. We worked together with all these law firms. We did discovery. We had over 3 million pages of documents that TVA produced. And over the course of 2 years, we prepared for trial and found out some interesting things. I mean, for instance, the inspector, who was the last inspector from TVA to inspect this dam, this coal ash dam, had never seen a coal ash dam before. And he didn't even know why he was in Kingston that day until he got there. And he sort of walked around, took some photographs, had no clue what he was doing. And he didn't even write his report until after the failure of the dam. And somehow or another, they thought they were going to pass off that report as being written before the failure of the dam. And after looking at several versions of electronic copies of this document, we finally figured out he wrote it after the failure of the dam. And there were some interesting photographs that he took to our geotechnical engineer who said that was going to fail. It was imminent. Another thing that it turned out that they did or didn't do was TVA had these piezometers. They measured the levels of water in the dam that they were supposed to be reporting to their engineers in Chattanooga, and they were taking these levels, and along about November of 2008, the levels spiked. But the people who were taking the measurements were sending them to Chattanooga to, guess who? The same engineer who had never even seen a coal ash dam before, who was just putting them in a file and didn't know what to do with them. So it was that kind of negligence that got the judge mad. I mean, Judge Varlin got mad. You could tell it visibly on his face during this case, during this trial. And he is not, I mean, he's a conservative federal judge and is a very mild-mannered person, but he was mad during this case. And he ended up writing a 130-page opinion. And, you know, we had given him about 100 pages of proposed findings of fact and conclusions of law. He went further than that, wrote 30 more. And you could tell from the tone of it. I mean, he thought TVA's management was extremely negligent. So he found them negligent. And so we ended up having to then figure out where we go from there. We have 7 law firms. We've got 850 clients. How do we try these cases? And just last December, we asked Judge Varlin to order TVA to mediation. They didn't want to settle. They didn't want to mediate. The judge ordered them to mediate. So we've been mediating now for 8 months, 9 months, and still haven't resolved the case. We're still trying. But just so you know, just along what else is going on, there was an EPA proposed coal ash rule that came out of the dam failure, and you know, this was proposed in 2010. Had 2 options: either regulation as a solid waste or regulation as a hazardous waste. And unfortunately, politics intervened. So here we are, more than 4 years later, after the coal ash disaster, and these standards are stuck. Congress has voted umpteen times, or the House has voted umpteen times, to stop EPA from going ahead and promulgating these rules. The latest effort was the Coal Ash Residuals Reuse and Management Act of 2013, which would prevent them from finalizing the rule. Litigation continues on coal ash, other than the fact of our litigation. Environmental groups sued EPA in April of 2012 to force them to promulgate the rules. And there have been several federal citizen suits under the Clean Water Act and RCRA regarding coal ash dams around the southeast in particular. The SCLC is doing some of them. Earth Justice is doing some of them. The Environmental Integrity Project, there's several. And there have been at least 3 other damage cases brought for people who live around coal ash ponds, like the one in Kingston. And thank God none of those have failed, like catastrophically, but they do pollute groundwater, they pollute surface water. And there are cases going on with the water pollution aspects here in Tennessee. So, I mean, this was a case where it was good to have friends in strange places. We we could not have done this lawsuit and gotten to the point of finding TBA liable. You have to remember, TBA has almost never been held liable for private tort actions because of this immunity, this discretionary function immunity they had. If the judge essentially ruled that if they undertake a policy to perform certain activities, that beyond the policy itself, they have to perform those activities in a non-negligent way. That's a chink in the armor with TBA that has rarely happened. It has happened in the Sixth Circuit anyway. It has happened since then in the Fourth Circuit in North Carolina versus TBA. It's happened in the Second Circuit with the Connecticut versus Appalachian, the American Electric Power, AEP. Jamie's going to talk about that case in his talk. So we're still stuck, though, on these coal ash rules. We got to get those out there. We got to make these facilities safer. And I don't. The problem with our case is it's just too much for a federal court to handle. We got 850 clients. The judge does not want to try 850 cases. Maybe if he had it to do over again, he would have certified a class and given us a jury and would have been done with that day. But he didn't do that. And class actions are under attack everywhere now, so I question whether class action practice is going to be useful in environmental torts like this in the future. But anyway, it's good to have friends like the groups, the law firms that I worked with and the environmental groups who have brought us cases like this before. As a result of this case, our firm has kind of gotten into a specialty of environmental disasters, I guess you might say, because we went on from the TBA case to work with the Friedman League firm on the BP oil spill. So we have hundreds of clients now throughout the Gulf in the BP oil spill. As a result of that, we got called in to Arkansas with the ExxonMobil pipeline rupture in Mayflower, Arkansas, and we've got clients there as well. So I don't know if it's a good specialty to have. I hope there aren't too many more environmental disasters like this, but it helps to be in the right place, I guess. Next law, and this is where it gets a little touchy-feely. You must be the change you want to see in the world. A corollary of that is you've got to do what you do for the right reason, and it's not about you, it's about your clients. When I started, after that Department of Energy case in Oak Ridge I told you about, I was riding pretty high after that, I'll have to say. I mean, to have a case like that as your first case. And the American Lawyer magazine did an article about me, and this is what they said about my environmental politics, which I would love to have. That's going to be on my epitaph, I think. But I didn't think about it at the time, but that particularly thorny bramble of unrehealable populism was describing an anger that I had. And it was an anger that came out of growing up in the 70s, the Vietnam War era. And it was an anger that came out of growing up in a very polluted environment. And it was, a generational anger that I had, and I brought that into my cases. And by God, I mean, it was good for energizing me, and you can't deny the energy you get from expressing anger against a lot of stuff. But if you have the perspective that you're beating a brick wall with a hammer, trying to knock it down, and it's them that you're begging to give justice to you because of your anger, you don't get anywhere with courts and juries. That's not the way you communicate to a conservative federal judge who used to work for a corporate defense firm and got put on the bench by a Republican president. You don't communicate that way to a federal judge like that. You don't communicate to a jury like that, who are typically composed of people with an average 6th grade education, who are not environmentalists, who do not start out being angry at the establishment. So I had to learn that anger, was not the most productive thing. And I learned it initially, and I keep coming back to this case, with this woman, his family I represented over in Wayne County, Tennessee. Margaret Gallagher is her name, and it's funny how things go in circles, because Margaret Gallagher originally came from a little place called Gallagher, Tennessee, which happens to be part of the Oak Ridge Reservation, and her family was kicked out of there when the facilities were built in the 40s. And so she ended up, and her family ended up in Wayne County since the 40s, and they she worked at the high school cafeteria. Her husband was elderly. She was in her 60s at the time, and he had two invalid elderly brothers that lived with them, and she took care of all three of them in this little house, modest home. Unfortunately, the county put a landfill near her home. And after a period of time, in the 70s, her well became contaminated by the garbage dump that Wayne County had put there. And she was hauling jugs of water from her home, for her home from the high school cafeteria every day to bathe her husband and his invalid brothers and to drink. And she couldn't wash her dishes, she couldn't wash her clothes in the water. And she came to me at a time when I was almost as poor as she was. My first year of law practice, I made $12,000. So, but she, and I wanted to help her in the worst way. She couldn't afford to pay me, and I was looking for a relatively inexpensive way to help her. And so we filed a complaint in front of the Tennessee Solid Waste Disposal Control Board. And I figured that was a lot cheaper than going to court. And the reason I come to this case when I talk about it's not about you as the attorney, it's about your client, is because she testified in front of the Solid Waste Disposal Control Board, which is comprised mostly of polluters. I mean, these boards that are appointed by the governor is mostly generators of hazardous waste, people who treat hazardous waste for solid waste, and so engineers, people who work for public agencies, those are the members of the Solid Waste Disposal Control Board. And when I started looking at the list of who was on it, I said, what was I thinking? But I approached it, I approached them with respect. I was not angry, and I let Ms. Gallagher do the talking. And she testified at length during that hearing, and she talked about how, she brought her dishes to the hearing, showing that they wouldn't come clean. There was this stuff caked on them, this oily residue on her dishes, and she brought jars of water that she had taken and a sample of the sediment from her hot water tank that she just talked to these people. And we had the Tennessee state geologist on the other side who came in and said, it's inconceivable that this landfill caused that problem. Inconceivable. And so in the end, though, these hard-boiled members of the Solid Waste Board not only found in her favor that the landfill had contaminated her well, but they wanted to give her a new water supply. We had asked for that. And so they ordered Wayne County to provide her a new water supply. And Wayne County appealed. They went to the Court of Appeals. Well, first they went to the Chancery Court, who upheld it, then the Tennessee Court of Appeals. The Tennessee Court of Appeals found, and this is a reported case, and unfortunately the first part is used against me all the time on material and substantial evidence. So when you challenge an agency in Tennessee, you're liable to get this case cited to you. That it's really a fairly minimal standard of review on appeal of the evidence that the agency uses to determine its findings. So in this case, they held that Ms. Gallagher's testimony especially convinced the board and convinced the Court of Appeals that the landfill had contaminated her well. That was great. But then they found, this is Judge Koch, who is now the Chief Justice of the Tennessee Supreme Court, wrote this opinion. found that unfortunately the Solid Waste Board overstepped its boundaries when it ordered a water supply. And it wasn't in the statutory authority of the Solid Waste Board. But they were so anxious to help this woman, and the Court of Appeals was anxious to help her because they suggested these assertions would support a claim for damages under a private nuisance theory if they were made in a court of competent jurisdiction. Well, guess what we did? and finally, after that, I thought maybe I should have gone to the Chancery Court to begin with, but I was able to go to the Chancery Court at that point and use collateral estoppel on these findings from the Solid Waste Board in a way to have the Chancery Court hold without us having to do anything that they had contaminated her well. So it was just then a matter of, yes, they provided her a water supply. And she paid me in quilts and jam. So that was how I got paid in that case. But whenever I find myself thinking it's about me, I remember this case, and it's about her. It's about the client, always. Finally, the fourth law of public interest environmental practice is desperate times call for desperate measures. That is, some of you might know that I'm a sailor, and I read a lot about the sailors of old, and Admiral Nelson of the British Navy said that. Desperate times call for desperate measures. He also said, never mind about maneuvers, go straight at them. And I use that in my law practice. And I think right now we do have desperate times. We've got the state legislatures that are trying to take us back. I mean, it used to be that the environment was a sacred cow and that no one was going to try to get rid of the Clean Water Act or the Clean Air Act. But now we've got, in North Carolina, for instance, they actually banned policies based on sea level change. You can't talk about sea level change if you're a North Carolina agency now. Opened part of the states to fracking, but then turned around and turned down EPA grant money that would allow them to study the baseline before the area's fracked. And then they fired members of the Environmental Management Commission so the governor could stack the commission. And all state environmental laws have to be reviewed during a very short time frame, or else they are repealed. Or not laws, I mean rules, or else they're repealed. And there's no way that's going to happen in the required time that the legislature has provided. In Tennessee, you can't talk about sustainability if you're an organization in Tennessee and get funding from the state, because that's a black helicopter United Nations plot. And you know, sustainability is the most conservative, and I use that in a little c, conservative approach to the environment that you can imagine, because it combines development with the environment. It's all about, you know, it's sustaining the economy while sustaining the environment, but that is too radical of a concept for the Tea Party these days. And then we've got enforcement that is pretty much stopped by TDEC. Unless we file a citizen suit notice, then on the 59th day they usually file something. And that TDEC refuses to regulate coal ash pollution from TVA power plants. That's another issue right now. And you know, if some of you are from other states, I'm sure you've got a litany of nightmares that are going on now. These are desperate times. I think we need public interest environmental lawyers more than ever. And it's just great to see so many people who are willing to sacrifice themselves, sacrifice what could be a lucrative career in the corporate world to be able to do what you're doing. A couple of go straight at them type of cases that you know, deal with desperate times. I'm not going to go into details about these. Some of you who are from North Carolina might remember the Duke Cliffside coal plant battle. It's still going on in some respects, but you couldn't pick a less friendly forum than perhaps the Solid Waste Disposal Control Board to be in as a public interest environmental lawyer than the Public Utility Commission. The North Carolina Public Utility Commission, is pretty much stacked like most of these agencies are, and there is a type of lawyer who practices utility law that it's all about the backroom deal. I mean, you never really litigate in the utility commissions, and you don't litigate like a trial lawyer usually. But we ended up representing the Southern Alliance for Clean Energy in challenging the Cliffside plant, and we went at them. We went straight at them. Went straight at Duke. Put their CEO on the stand, Jim Rogers, went straight at him. We ended up getting the Public Utilities Commission to deny one of their 2 plants. They were going to have 2 units and one was denied. But these are desperate times, and we'll go anywhere to try to fight a coal plant because of their obvious impact. We can't afford any more coal plants in this country. SACE also has been challenging the nuclear cost recovery provision in Florida that allows utilities to charge their customers for nuclear power plants that are likely never to get built, and charge them as they go. So the entire risk is shifted to the ratepayers, and Jamie and I both have been in front of the Florida Public Service Commission, again the same kind of forum where you really don't want to be as a public interest environmental lawyer, but desperate times call for desperate measures. How many of you out there have ever brought a case that you didn't expect to win? Well, of course. But you got to do something now. And if we sit around as public interest environmental lawyers and try to only bring cases that we know we're going to win, we'll never get anywhere. And if we sit around and ponder, is litigation the best strategy? It's too late. It's gone. I mean, whatever you're trying to protect is gone. I just, again, desperate times call for desperate measures, and just go straight at it. That's all we got to do now. I mean, I think if we don't, we're going to lose what we have. And it's going backwards faster than I've seen it in 30 years. But let me close by just saying that public interest environmental law practice has come a long way in the 30 years I've been doing it. And I just never expected to see so many lawyers who were as crazy as I was out there trying to maintain this kind of practice. We're needed more than ever now. The challenges to our health and environment are growing every day. We got global warming, we have fracking, mountaintop removal, air pollution, toxic chemical waste is still out there, even nobody's talking about it today. Tea Party Republicans are taking over state legislatures. We got to keep working hard. We got to keep fighting. And I really commend you for making the choice to be here today, for making a choice to practice in this area. And thank you. And if anyone has any questions, I'll take them now. Yeah.
So Gary, what is the status with the regulation of coal ash at the moment? Is it just frozen where it was 5 years ago?
It is. I mean, EPA has not moved forward on the rule. The environmental groups, as I mentioned, have sued to try to pry it out of them. And that lawsuit is still pending. I haven't checked in on it recently, but there was some motion practice going on.
So in what respect is it regulated today?
Well, it's regulated by the states. It's regulated differently by different states. I mean, Tennessee regulated that mess out there in Kingston as a solid waste landfill. Okay. So it was like a garbage dump. I mean, it's the way they treated it under their rules. And obviously that didn't work because there were no dam safety requirements that were part of the solid waste rules. And that was the big issue. I mean, had TVA applied the same rules it does and the same practices it does to their dams for reservoirs, this would have never happened. It would have never happened. Brian?
Gary, there was just a court order that the EPA is going to have to adopt the coal ash rule.
Great, great.
They've actually been court order now that, okay, you sat around for several years, choose, do it.
That's great, thanks for that update.
On this Tennessee legislature banning funding of organizations promoting sustainability, sort of interesting in the fact that the city of Knoxville has a sustainability department. Does that mean we don't get any state funding anymore?
I wouldn't use that term too often, anyway.
Well.
But, and I don't know what they're doing. I don't know how they're implementing it, but and that's, I don't even have the text of the
Call the mayor.
legislation. Yeah. Okay.
Is there an alternative term that one can use to fit in with the
Don't-
ideological slant?
Don't use Agenda 21. I don't.
I live in Nashville and was involved in the legislative issue, and I don't believe that actually passed. It is true that the term sustainability was under attack in that way, but I think we stopped that from getting passed.
Well, that's good. Okay.
Isn't that true?
I'm not sure. I don't have the actual statute.
Is sustainability in one of their divisions, so I don't think the Tea Party was successful in the legislature.
Good.
It certainly was a part of
They're
Agenda
trying to.
21.
I'm sure you had something to do with that, Mary.
We actually had the sponsor of that bill out helping us build a rain garden the other day. And she inadvertently has been involved in sustainability. So.
That's great, John.
Gary, I think your playbook is real good, all 4 points. And you elucidated all of the bad things that are happening in North Carolina with regard to hydrofracking. And understanding that, and with that kind of a background, we have started working on an issue which is not really an environmental issue at all. And so maybe it's created some strange bedfellows in terms of forced pooling and also split estates. And people are finding out that people that don't care much about the environment or wouldn't care about the environment at first are concerned because their property values, their property rights, I should say, are undermined by that industry, and they are not happy about it. And so there's a whole rebellion going on there that we're a different tack, in other words, than the Clean Air Act, Clean Water Act.
Well, and when I do a nuisance case, I don't talk about the environment. I talk about property rights.
Yeah.
That's exactly right. Yeah. Thanks, John. We done?
Yeah, we're done.
All right.
Few announcements for y'all before you go.
Thanks for coming, everybody.